Now, so much for the principles. Let's turn to what we've actually done. There are subtle changes in some areas and rather more significant changes in others. And I want to just pick up right from can you make an offer in this type of case, to making the offer, to its acceptance, and to the consequences after trial, and just follow through with you what the changes are. And then pick up a couple of points at the end about the split trial problem that Neil mentioned in opening. What we've started with here is in Rule 2, at paragraph 3 of it, there's a statement of when you can use Part 36, which simply wasn't there in this way before. And what does it tell you? You can use it to settle the whole of a claim, or part of a claim, or an issue in a claim. No change there. That was in the old rules. Secondly, you can do it to make an offer in respect of a claim, a counterclaim, or other additional claim. Now, the counterclaim and other additional claim was not something that was there before, and I'm going to talk a bit more about those problems that I hope we've solved in a moment. You can also use it in appeal proceedings, and more of that, again, in a moment. What is not in Rule 36.2, and it never was, but just for completeness, so that somebody doesn't think I've overlooked it, if you're a costs lawyer, and I was speaking to one just before we started who was asking about the way in which we've dealt with this, Rule 47.20 is the rule that applies in detailed assessment proceedings, Part 36, to those costs proceedings. It's still there. It's been tweaked slightly to take into account the new Part 36, but it's still there. This talk, though, is about making Part 36 offers in substantive litigation rather than in the detailed assessment proceedings. It contains, for example, the rules that tell you that within Part 36, when you apply it, for claimant, read receiving party, for defendant, read paying party, and the like. All of that detail is still there. What I want to pick up on, though, are these two matters. So if we look at counterclaims, first of all, there was a problem with this. Very youthful as he was when he was appointed, almost Harry Potter-like, Mr. Justice Philip Sales decided this case, F&C Alternative Investments and Barthélemy, in 2011. And it was a case in which there was a counterclaim by the defendant shareholders, effectively petitioning for unfair prejudice by way of counterclaim. And they believed that they were going to be the ultimate winners of this litigation, and they wanted to make an offer as to how much they would accept on their counterclaim. But they reasoned that if you look at Part 36, defendants have to pay the costs of the claimant when they accept a Part 36, when their offer is accepted by the claimant. And therefore, they reasoned that there's a glitch in Part 36, it doesn't work. And so they wrote a rather elaborate letter that explained this glitch, explained they would like to have been able to make a Part 36 offer, but they couldn't because of this rule that defendants have to pay costs on acceptance. And as a result, they said, we're fashioning this offer we make to you by analogy with Part 36, and at the end of the case, we would like, if it's effective, we would like our indemnity costs and the like. Unfortunately, Mr. Justice Sales bought that, and he ordered indemnity costs. He was wrong to do so. The appeal heard by, well, Lord Justice Davis gave the main judgment on the appeal, Arden and Tomlinson, the fellow members of the court. And what Lord Justice Davis said is that, no, Part 36 consequences only flow if it's a Part 36 offer. If it's not a Part 36 offer, you're into Rule 44.2, the obligation of the court to take any offer into account in its exercise of discretion on costs. So he got it wrong. What's odd about the case, and Philip Sales and I have discussed it because he was a member of the Rule Committee. He was actually serving on my subcommittee before he himself was promoted to the Court of Appeal last autumn. And the oddity is that nobody cited to him Rules 20.2 and 20.3. Fellow anoraks will know that those are the rules in the CPR that say that when you make a counterclaim or other additional claim, it's treated for the purposes of the rest of the rules, where appropriate, as if it were a claim. That for defendant, read claimant, for claimant, read defendant. That is what those rules say. And it's the neat little device so that they don't have to keep banging on about counterclaims through the rest of the rules. And that wasn't cited, nor this decision of Lord Justice Lloyd and Reimer in 2009, AF and BG, in which they confirmed, because it was argued the other way, that these rules did indeed mean that a counter-claiming defendant can make a claimant's Part 36 offer. And that was the point that was missed in F&C. So what have we done? If you look at 36.2, at the bottom of page 2, and para 3, we've clarified for the first time. It's not a change of law, but it's there in order, I hope, to be clear, that this does apply to counterclaims, it does apply to additional claims. If you needed more, you get the signpost. You see it in brackets at the end of our new paragraph. So rush off and look at those rules, and you would find out the answer. And if you still need more persuading that we've done something about the problem, many of you, I'm sure, as sophisticated lawyers, won't actually use the court form. You'll probably bespoke your letters. For those who like using court forms, N242A is the court form on which you can make your Part 36 offer. We've rewritten it. I would love to be able to show it to you. I checked with the Secretary to the Rules Committee last week where it was, having agreed with the committee in December the drafting, and apparently it's with Her Majesty's Stationery Office, and I can't show it to you. But when you see it, as I say, if you like using forms, when you see it, it has been rewritten, and it will make clear, particularly with guidance notes in it, that you can, as a counterclaiming defendant, if you want to, make a claimant's offer. Now, you need to think it through carefully, because, of course, you might be making a defendant's offer. It might be that your counterclaim has no merit, or it might be that your counterclaim is so small that all it can really do is achieve some partial set-off against the claim. And if so, you might be making a defendant's offer, but you need to think through which you are doing. That's counterclaims. I want to talk about appeals briefly. I'll quickly bring up the old rules here. It was there. You had to look in several places to find it, but you can, at the moment, make Part 36 offers in appeal proceedings. You do need to make a new offer in the appeal proceedings. The offer you've made at first instance does not automatically apply to the appeal, so you need to, as I say, make a new one. First thing we've done is, in our Rule 36.2.3 that we've been looking at, we've clarified that appeals apply, but we've added cross appeals. The logic of that is obviously the F&C point. If you can make an offer on a counterclaim, you ought to be able to on your cross appeal. And what we hope is the net effect of these new rules is that there is no class of litigant who can't make an effective Part 36 offer. It doesn't matter whether you're claimant defendant, whether you're defendant with a counterclaim, whether you're a third party, a defendant to a third party claim, whether you're an appellant, a respondent with or without a cross appeal, you can make a Part 36 offer, is at least our intention. But there's one point of detail I ought to take you to on what we've done here. We do say an appeal or cross appeal from a decision made at trial. And the logic's really this, that you can't make a Part 36 offer to settle a specific disclosure application or any other interlocutory application. You can make your offer without prejudice, saves costs, of course, but Part 36 has no place in interlocutory proceedings at first instance. And it seemed to us, particularly given that not all appeals are fancy ones off to the Court of Appeal or Supreme Court, that we ought to have the same rule. You can use Part 44 to your heart's content in an interlocutory appeal, but Part 36 won't help you on interlocutory appeals. The other thing we've done, if you turn to page 4 of the notes, there is a particular rule at 36.4 that just explains a little bit more about the application of Part 36 to appeals. The first paragraph of it confirms the point that we've got here, that you do need to make a new offer in your appeal proceedings. And the second paragraph, I can tell you this, the one you've got in your hands is about draft 14 of Part 36 that I've worked on. Versions 1 to 6 had within them throughout, when we took that claimant, or appellant, claim or appeal. And when we actually stood back and looked at the drafting, it was even less intelligible than the stuff you've now got in front of you. And I hit on this idea of putting a little table together there. It's really modelled on the Rule 20 solution. The idea being that this tells you how to read Part 36 as applying to the appeal case.